Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Hello. Special shout out to Melissa, aka Turd Ferguson, for the new theme song. Thank you so much, Melissa. I love it. Love it. Threw together a little intro yesterday. Somebody said they missed the old intro. Oh, please. I'm not a cupcake. Can't please everybody. See that pink sign right there? You are not a cupcake. You can't make everyone happy. You're not a cupcake. That's me. I'm not a cupcake. But thank you all for being here today, my cupcakes. And special shout out to Romy for sponsoring today's show. If you know, you know. Or IYK. MakeStickers.com does not sponsor me, but they should. How's everyone today? How is everyone today? Today we have in our possession the brief from the Commonwealth. The deadline was yesterday, as you know. Yesterday we were fortunate enough to get our hands on the brief that the ACLU filed. The amicus brief filed by the ACLU in the Karen Reed appeal. There's Romy. Hi, Romy. Thank you, Romy. Everyone say hi to Romy. Kisses. So we did the ACLU brief yesterday, and today we have the pleasure of looking at the Commonwealth's brief for the appellate issue that is going to be argued orally in front of the SJC in... Is it in Dedham as well, the SJC? I don't know. Actually, I don't know where the SJC sits. November 6th. And we're going to cover that live as well, because who doesn't love a little oral argument? We've missed it. We've missed it. I miss the fan. I miss hearing God save the Commonwealth every morning. But if God can't save the Commonwealth, maybe I can help with that. And Mark Betterow is definitely going to help with that. So he's not here today, but he is appearing, as you know, in Dedham and District Court on behalf of famous journalists from your area. So if you know, you know. Hello, Finland. Hello, Finland. Did you change your name? Did you change your name? Because somebody wrote in my comments something stupid yesterday, like I mispronounced your name. So I'm not even going to try and pronounce it again. It wasn't you. It was obviously someone else. Hello, Finland. The world is watching. Thank you, Martin Rich, for becoming a new member. Thank you, Hate Corruption, for becoming a new member. And Jedi Jen, you guys are really being creative with your screen names, and I'm here for it. I'm so here for it. How's everybody doing today? Give everybody a chance to come in. This was a last minute live, as always, because as you know, I'm at your service for breaking news. Yesterday, I did 3 streams, all that were pretty much last minute. We did the Robert Tellis sentencing in the morning in Las Vegas. And then we went to LA for the Mark Garagos press conference regarding the Menendez brothers. And so many family members of the Menendez brothers spoke, and they are all very supportive of the Menendez brothers getting out of jail. They think that they've done their time. They say that they know that they were abused horrifically by Jose Menendez. And there were people from both sides of the family that came to speak in support of them. And if you haven't watched it, go back and watch it. It's pretty fascinating. You don't often see that, where family members of the victims come out in support of the convicted. So it's interesting. And then, of course, yesterday we did the ACLU brief in the afternoon. So it was a busy day, but it's always fun to do improv and do it on the sly. Hello, Adam Lally's resignation. Today's your 32nd wedding anniversary, and we're both sick on the couch. Well, happy anniversary to you both. I'm glad to be here to entertain you, hopefully, for your anniversary. Just, order some Uber Eats or something. You can always go out to eat another night. And tell us what your secret is for being married for 32 years. Please. Is there a secret? My father said, and I think he stole this from somewhere. He said, don't marry the person that you want to live with. Marry the person that you can't live without. Interesting. My parents were married for well over 50 years. So there's that. It was so moving, wasn't it, Magnolia Gypsy? So moving. All right, anonymous Canadian girl, we are so happy that you made it for our live. I hope you had a wonderful Thanksgiving. Monday was Thanksgiving in Canada. Oh, thank you for subscribing, Dave. Thanks, Dave, for coming in from the Boston Laborers Union. Union strong. I like it. Nice to see me. Just subscribe. Love the job you're all doing for Karen. Keep up the great work. Thanks. I like to speak out about a lot of different cases that I feel passionately about. And you guys know how I feel about them, because if I wasn't passionate about it, I just wouldn't cover it. Hello, my miracle mama. My email, I will drop it in the chat. It's fanbase@mlittlelaw.com. That's fanbase@mlittlelaw.com. I don't always get a chance to respond to emails, but I do always read them. So feel free to email me. Tips, tricks, thoughts, concerns. Unless it's mean, then I'll just block you. I love you so much. Thank you for coming in with a 5. And look at Lori, Life 360 for the win. Life 360 for the win is right. For gifting 5 memberships. And welcome to the 5 of you who are randomly selected by the gods of YouTube. Thank you, allegedly, LB, for becoming a new member. And hate corruption. Glad to be back in the USA. I missed you guys. Where have you been? Where have you been? Hi, Monica. No, I have not watched the Farris trial, so I have no thoughts to give you. I'm very sorry. Have you watched it? There's too much going on. I just don't have the time. I also am a mother of 5. I mean, I'm a busy lady. So tell me, if you think it's worth going over, absolutely. Love to hear your thoughts. What is going on with, I haven't even had a chance to see what's going on with Sarah Boone. Is the jury, are they done picking the jury? Are they going to be starting the opening statements today? Because I got the thumbnail ready. Like, if we have to roll into opening statements for Sarah Boone, we can do that. Thank you, South Africa and Bernadine Bush, for coming in all the way from South Africa. Look at Good Citizens' little profile pic. So adorbs. It's like a little grandma rubber ducky. Hey, Auntie Beb's fait accompli. Bonsoir. Bonsoir. Not yet. Okay. So they're still picking? They're still picking. We got nothing. All right. Still doing motions. No snacks for Sarah. Oh, what a bummer. What a bummer. Think jury instructions will be this afternoon? All right. We'll see. We're here. We're always very spontaneous. It's a very spontaneous and collaborative channel. You guys are yes, I am. Thanks, Susie. All mine too. All mine. You can't have them. So there is that. Okay. And look, Germany is in the chat. Hello, Berlin. Hello, Kristen in Berlin. We have so many Kristens and Kirstens in this community. And there are also a lot of Melanies, which is interesting too. Gen Xers in the chat, and always and everywhere. We've been waiting for the red brief. The blue brief had been filed. We were waiting for the red brief, and here it is. And it's really red. Look at that. It's really red. It's really red in the case of Karen Reed, which you could also pronounce as red. The things that get me off on a tangent. This is the Commonwealth's brief. On a reservation and report by the single justice of a petition for extraordinary relief pursuant to GLC 211, Section 3. This is the Commonwealth's brief, and it is Signed by, well, it's not really signed on this page, but Michael Morrissey, Caleb Schillinger, Adam Lally, and Laura McLaughlin, as we like to say. And of course, I had to do a deep dive into Caleb Schillinger because we have not seen his name before. And what I was able to find for you, he's a Harvard-educated attorney. He went to Harvard Law. He went to Harvard. He's I'm sure, very smart, wicked smart, I should say, wicked smart. And he may be their appellate counsel. He's on staff, actually, at Norfolk ADA's office. Why did it go away? Hold on. So he has been with Norfolk DA's office. He's an ADA there. He's been there for 2 years, since September 2022. I know he's from Canton, but it says Canton, Massachusetts in his profile on LinkedIn. Before that, he was a partner at a firm called Shayfarth Shaw in the greater Boston area. Before that, he was an associate. That's a firm called Bingham McCutcheon. He was with Dewey and LaBeouf. Graduated Harvard Law School in 2009. So he's wicked smart. And before that, he went to the University of Michigan, graduated from the University of Michigan with a major in naval architecture and marine engineering. Yeah, he's wicked smart. He's wicked smart. Let's see what his writing style is like, shall we? Oh, I guess I can't even. Don't get me on a tangent about Liam Payne. I'm very upset. My youngest daughter and I watched the One Direction movie last night in solidarity, and it was very sad. And I don't know what's going on there. Apparently, he had a lot of problems, a lot of rumors. I don't want to speculate, but let us just say R.I.P. Liam Payne. And watching back that movie on One Direction when they were so young, I mean, these kids were on X Factor or whatever that Simon Cowell show was in the UK all the way back in 2010. They got famous when they were like 15, 16. And he was like the dad of the group. So tragic, so sad. If you guys are interested in that story, I will cover it. Let me know. I mean, you guys let me know what you're interested in all the time. And I cover the things that you're interested in. So let me know. All right. See what what Caleb Schillinger has got in the writing department. This was just the deadline was yesterday. It is dated October 16th. I don't think it was logged into the court docket until today, which just may mean that the clerk didn't log it in. It doesn't mean the brief is late. Don't flip out about that. Look at this. Oh, sweetie. Oh, sweetie, no. I went to Harvard, and I'm here to tell you all smart and sensible don't always overlap. Yes. Oh, yes. Oh, yes. Oh, yes. Rubber Ducky Posse. My kids grew up on One Direction are devastated. Yeah. Yeah. So sad. Please cover Liam. You want to cover Liam or Sarah Boone? If you want me to cover Liam, just write Liam in the chat or hashtag Liam or something like that. So I'll see it and go back and count it later. Okay. Here's the table of contents. This brief in its entirety is 77 pages, but much of it is exhibits and the original decision by Judge Beverly Canone. Somebody sees the document as orange. I don't know. Could be the coloring on your screen. Could be maybe you're colorblind. I don't know. To me, it looks red, but they call it the red brief in the court docket. Here is the summary of the arguments, table of contents, conclusion, addendum. So it goes about 52 pages. We can do it. We've done it before, and we're going to do it again. I'll put on my best ASMR voice for you so that hopefully it's not grating on your nerves. Traffic court. Scott wants us to go to traffic court. Would that be easier for you, Scott? I thought you like a challenge. I thought you like handing out boarding passes to Block Island. Boone's Farm. Liam Payne was a member of One Direction who tragically fell from a third-floor hotel balcony yesterday in Buenos Aires, Argentina, where he had been to see his former bandmate of One Direction, Niall, perform, and sadly passed away. Liam Payne, thank you. I'm not colorblind. If we go to traffic court, we'll have our asses up. Okay. All right. If you can find me some coverage of traffic court. The other fun thing we could do, Scott, is just look at the Bourbon County Detention Center and go through the thumbnail headshots, mug shots. That Kentucky case that I started handling, that Toralina May Fields case, is wacky. She dismembered her mother, and then they found her in a pot in the oven. It's so tragic. Drugs are bad. Don't do drugs. Table of authorities. Here we go. They got lots of case law. Let's see if they cite any of the same cases that we saw yesterday in the ACLU brief, or if they're just going to cite the cases that they think are good for them. All right, good. We have time then on Sarah Boone. We have time to get through this before, if and when, if ever, we go to Florida for Boone. Liam Payne was 31. 31. Am I skipping? You mean skipping like my audio is skipping? Or my video is skipping? Scott, let me know. Let me know. Testing 1 2. Testing 1 2. Testing. I'm on Ethernet, so oh no, you know what? I'm not on Ethernet. Hold on. Thank you. Going to Ethernet now. Just hang on, everyone. Hold on to your seats. See if it'll flip over. Better? Yannetti Spaghetti. Loves a good mug shot. All right. I'm on Ethernet now. Thank you. Thanks for saying that anyway, because then I got there. Okay. It's hard for me to read the chat while I'm reading to you because I have to enlarge this to a very large font for myself. So if you wouldn't mind saving your questions for later, Scott, if there's anything pertinent that needs to be addressed, you know how to reach me, right? Say no more. Say no more. All right. Let's say goodbye to Yannetti Spaghetti for now. Canoni needs a boarding pass. Somebody said if it's skipping, just refresh your page. Okay, here are the issues presented according to the Commonwealth. Interestingly enough, Kentucky is also a Commonwealth. I found out Kentucky is a Commonwealth, Pennsylvania, Virginia. Okay, I'm going to try not to digress anymore, you guys. Issues presented. 1, the jury reported 3 times in increasingly sharper terms that it was deadlocked. Its third and final note said that the jurors remained starkly divided over the charges and further deliberations would be futile. At no point did the jury express the prospect of unanimity on any charge, and the defendant argued at the time that the jurors were at an impasse and hopelessly deadlocked. Did the trial judge abuse her discretion in declaring a mistrial based on the deadlock reported by the jury? Roman 2. The defendant did not object to the declaration of the mistrial. The judge found that the defense counsel had multiple opportunities to raise any objection, and she explicitly found not credible the defendant's assertions that the mistrial was sudden and unexpected, or that defense counsel was not afforded an opportunity to be heard. Did the judge err in concluding the defendant consented to the mistrial? Roman 3. The jury did not return, announce, and affirm any verdicts in open court. Was the defendant acquitted of the charges of second-degree murder and leaving the scene? Statement of the case. Oh, how many statements of the case did we go over pre-trial? And it kept changing. This time they don't get more than one bite at the apple. This is their statement of the case for this appeal. That is it. On June 9th of 2022, a Norfolk County grand jury indicted the defendant, Karen Reed, for murder in the second degree, manslaughter while operating a motor vehicle under the influence of alcohol or having a blood alcohol concentration of 0.08 or greater, OUI manslaughter, and leaving the scene of personal injury resulting in death. Footnote 1. The record appendix is cited as R, the Commonwealth Supplemental Record Appendix as SR, the defendant's brief as DBR, and the addendum to this brief as ADD. This is giving me ADD. All citations are followed by page numbers. Well, thank you, Mr. Schillinger, counselor, my brother. The jury trial on the 3 indictments began on April 16th, 2024. Beverly J. Canone presiding. Feels like a year. Doesn't it feel like a year ago? April 16th. Wow. On June 25th, 2024, the 37th day of trial, the jury began deliberating. In addition to the 3 charged offenses, the trial judge instructed the jury on 2 lesser included offenses of OUI manslaughter. 1, involuntary manslaughter by wanton or reckless conduct, and 2, motor vehicle homicide by negligent operation while under the influence of alcohol. On July 1st, 2024, the 5th day of deliberations, the trial judge declared a mistrial based on jury deadlock. Okay, I have their supplemental record appendix also pulled up. So we're going to go, I think we'll go to those exhibits as they talk about them, which we're not up to yet. On July 8th, 2024, the defendant moved to dismiss the charges of second-degree murder and leaving the scene on double jeopardy grounds. The motion was accompanied by 2 affidavits from her attorneys. The Commonwealth filed a written opposition to the motion, and the defendant filed a reply. The defendant also filed 3 supplemental memoranda, each accompanied by an affidavit of counsel. On August 9th, 2024, the trial judge heard argument on the motion. In a memorandum of decision and order entered on August 23rd, 2024, the judge denied the motion. On September 11th, 2024, the defendant filed in the county court a petition for extraordinary relief pursuant to General Law 211, Section 3, seeking review of the order denying her motion to dismiss. A single justice, Elizabeth N. Dewar, D-E-W-A-R, reserved and reported the case without decision for determination by this court. Statement of the facts. A, jury, deadlock, and mistrial. The jury began its deliberations on Tuesday, June 25th, 2024, at about 1:25 p.m. Deliberations continued over the next 3 days. On Friday, June 28th, around noon, the jury foreperson sent the trial judge a note stating, we're going to pull up the note. And I want to look at the note because I don't think we've ever seen the actual physical note, have we? Because we're going to see it now. And we're going to, I'd love to have a handwriting analyst analyze this note, but maybe we can do that some other day. Here's the note. It's now part of the appellate record. It's public record. Here it is. Dear Judge Canone, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. And you see there that is signed, I think, by the foreperson. That's blocked out. And it is dated 6/28/24 in blue pen. The judge asked the parties for their views on whether that at that point the jury had engaged in, quote, due and thorough deliberations. Footnote 2. And they are quoting the statute. If a jury, after due and thorough deliberation, returns to court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. The Commonwealth asserted that the jury had not had sufficient time to deliberate, and it was therefore too soon to give a Tui Rodriguez instruction. Footnote 3. See Commonwealth v. Rodriguez, proving modified version of charge set out in Commonwealth v. Tui for prospective use with deadlock juries. The Commonwealth noted that although the jury said it had not reached a unanimous verdict, it did not convey that doing so would not be possible. The defendant disagreed with the Commonwealth's, quote, characterization of the note and argued that the jury was communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and that they are at an impasse. Defense counsel asked the judge to give the Tui Rodriguez instruction. The judge ruled that there had not yet been due and thorough deliberation given the length of the trial, the amount of evidence presented through 74 witnesses and 657 exhibits. The complexity of the issues, and that each of the prior days of deliberations had been shortened. Yeah, I mean, this trial schedule was crazy. 74 witnesses, 657 exhibits. She instructed the jurors to continue deliberating. They deliberated until about 4:15 p.m. when the judge released them for the weekend. Deliberations resumed on Monday, July 1st. At around 10:45 a.m., the jury sent the judge the following note. Let's go to the note. Judge Canone, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. Looks like the same handwriting, dated 7/1/24, and I imagine that it is also signed by the foreperson. The judge again requested argument on whether there had been due and thorough deliberation. The Commonwealth acknowledged the length of the deliberations up to that point, around 22 or 23 hours in total by its estimation, but it argued that the jury still had not conducted a thorough deliberation considering the trial length, voluminous evidence, and complex issues. The defendant argued that it was time for a Tui Rodriguez, as the jury had come back now twice, indicating essentially that they are hopelessly deadlocked. Defense counsel again asked the judge to give the instruction. The judge found that the jury had engaged in due and thorough deliberation, noting the jury had been, quote, extraordinary, and that she had never seen a note like this reporting to be at an impasse. She gave the jury the full Tui Rodriguez charge, and deliberations resumed. That was what time? $10:45. She sends them back. And they come back at 2:30. At about 2:30 p.m. that same day, the jury sent another note to the judge. The parties returned to the courtroom, and the case was called. And the judge informed counsel the jury is at an impasse. After the jurors entered the courtroom, the judge read the note aloud. Streamer doesn't make it easy for me to flip between windows, only tabs, so it takes a little bit longer, but I know you guys are patient with me. Judge Canone, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. And then you see in the document that I'm reading, they add a period in, but you can see there's no period after the end of the sentence. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Dated July 1st, 2024. And it looks like it's signed by the foreperson again. I wonder if the foreperson asked for any input in these notes or if the foreperson just took it upon him or herself to write the note. I wonder if the person cleared it with the jury and they all agreed that that's what the note should say. I don't know. We're not allowed to talk about, obviously, we're not allowed to delve into the inner workings of the jury. But in my opinion, we can ask the jury what they decided, whether they acquitted on charges. But we'll see if the appellate court agrees with me. The judge told the jurors, "I am not going to do that to you folks. Your service is complete." She declared a mistrial and excused them to the jury room where she said she would see them in a few minutes. The judge and counsel remained in the courtroom and scheduled a date to return for a status conference. It's a good question, Silent Murmur. Does it mean the state is using the note that says the jury is unable to reach unanimity to justify the ignorance of the two verdicts? Well, we're going to keep reading and you're going to find out. But that is the basis of their argument, in part, that the note was very clear that there was no reason for the judge to poll the jury or ask the jury if they were deadlocked on all or some of the charges. But remember, we went over the jury instructions several times. Okay, I'm an experienced trial lawyer with over 30 years under my belt in New York State and federal courts, and they were very confusing to me, those jury instructions. And she specifically told them, do not report back to the court until you have reached a unanimous verdict on all of the charges. I think she even said, did she even say, don't even fill out the papers until you've reached a unanimous verdict on all of the charges? Okay. B, purported post-trial juror statements. 1 week later, on July 8th, the defendant filed her motion to dismiss along with affidavits from her counsel, attorneys Alan Jackson and David Yannetti. Smooth as butter. Let's see the smooth as butter emoji. There we go. Oops. Got some trolls mixed in there. Smooth as butter, Alan Jackson. We didn't make David Yannetti an emoji. We should. Think about it, guys. Think about it. Attorney Jackson's affidavit said that on July 2nd, a purported juror, if you're in the South, Juror A, contacted him. He said he was able to identify which juror they were from his conversation with them. According to Attorney Jackson's description of the conversation, Juror A said the jury had unanimously agreed that the defendant was not guilty of second-degree murder, count 1, and shortly following that determination, they also had unanimously agreed that she was not guilty of leaving the scene, count 3. Attorney Yannetti's affidavit said that he had received communications from 2 informants, both on July 3rd. He said one of these informants, Informant B, sent him a screenshot that Informant B had received from some other person, Intermediary B, of text messages that Intermediary B allegedly had received from a purported juror. All right, I'm really hoarse. Attorney Yannetti believed he could confirm Juror B had been a deliberating juror based on the first name for Juror B given to him by the Informant B. According to Attorney Yannetti's description of the screenshot, Juror B allegedly texted Intermediary B, it was not guilty on second degree, and split in half for the second charge. When the judge sent us back with that Hernandez, sick, meaning that's what the person actually said, thing to look at the other side, it turned into a bully match. Yeah, remember that? When the judge, okay, so that was after that person meant to say Tui Rodriguez. To look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. And that's what it actually said. Attorney Yannetti stated that the other informant, informant C, had contacted him to say that they personally knew a purported juror, juror C, as they and juror C used to work together and had a mutual friend, intermediary C, who was a current co-worker and friend of juror C. Informant C also knew from intermediary C that juror C would be participating in a Zoom meeting with friends to discuss the trial. 3 days later, informant C sent attorney Yannetti screenshots of text messages exchanged by informant C and intermediary C, in which intermediary C purportedly reported what juror C had allegedly said during the Zoom meeting. Okay, my head is spinning from that paragraph. Let me just read that again for my own personal reading comprehension. That's not the way that I remember it. That this person, he or she contacted Yannetti and said there's going to be a Zoom meeting and then sent him screenshots after the Zoom meeting that there was more than one contact with this person. Do you guys remember it that way? Three layers of hearsay. Yeah, it's a lot of hearsay. But again, in Massachusetts, the attorney is not allowed to speak to the jurors directly unless they're contacted. So, for purposes of the motion, the hearsay was actually weighed by Judge Canone, and she said that for purposes of the motion, she was deeming all of these allegations to be true. So there's that. Yeah, people are saying, no, I don't remember it that way. Right, Dr. Tracy, I thought it was supposed to be decided on facts, not deeply held convictions. It's confusing. Stephanie, what did Stephanie say? You think a Harvard educated lawyer could learn how to not write run on paragraphs? And yeah, I didn't think that that's how it happened. I didn't think there was like multiple communications with the intermediary, but I could be wrong. It could be. I don't have a photographic memory. The Canton Leaf Blower Society is here, always right outside my window. Love it. According to Attorney Yannetti's representation of that exchange, intermediary C texted, "No consideration for murder two." Manslaughter started polling at 6-6, then ended deadlocked at 4 no, 8 yes. Informant C texted back, "If it was no consideration for murder two, shouldn't she have been acquitted on that count and hung on the remaining charges?" And intermediary C responded, "She should have been acquitted. I agree. Yes, the remaining charges were what they were hung on." Based on the descriptions of juror C by informant C and intermediary C, attorney Yannetti said he could positively identify juror C as a deliberating juror. On July 10th, attorney Jackson submitted a supplemental affidavit stating that on July 8th, he was contacted by a purported juror, juror D. I love this. Hold on. Go to the chat for a second. This is great. This is great. Hold on. Wait, where is it? Somebody had a comment about what Yannetti's emoji should be. Oh man, I lost it. It said something like Yannetti's emoji should be a diamond because he's solid as a rock and he's been Karen's rock since the beginning of the trial. So shout out to whoever put that in the chat. I just can't find the comment right now to highlight you. We love Yannetti. Mrs. Yannetti and Tanis, if you're watching, you did a great job with your brother and your son. On July 10th, Attorney Jackson submitted a supplemental affidavit stating that on July 8th, he was contacted by a purported juror, juror D. He said he was able to identify which juror they were from his conversation with them. According to Attorney Jackson's description of the conversation, Juror D said the jury had unanimously agreed the defendant was not guilty of counts 1 and 3, and the jury's disagreement was solely as to count 2 and its lesser included offenses. Attorney Jackson submitted a second supplemental affidavit on July 18th. He stated that he had been contacted the day before, July 17th, by a purported juror, Juror E. He again said he could identify the individual as a deliberating juror, period. According to Attorney Jackson, Juror E said the jury was unanimous on 1 and 3, the defendant was not guilty, and the jurors deadlocked only on the lower charges on count 2. On August 1st, 2024, the Commonwealth filed in the trial court a notice disclosing that on July 21st, an unsolicited voicemail was left on the office phone line of one of the trial prosecutors. The caller, who identified themselves as a juror by full name and seat number, stated, "It is true what has come out recently about the jury being unanimous on charges 1 and 3. That same individual left another unsolicited voicemail for the prosecutor on July 26, stating that they can confirm unanimous on charges 1 and 3 as not guilty, and as of last vote, 9-3 guilty on the manslaughter charges, on the lower level manslaughter charges, meaning the lesser includeds." Oh, is Screaming Mimi? Screaming Mimi Sue says Team Brittany made that comment about the diamond. Thank you so much, Team Brittany, for pointing that out and for giving credit where credit is due. The Commonwealth's notice further disclosed that it had also received emails from 3 individuals who identified themselves as jurors and wished to speak anonymously. The Commonwealth had responded to the emails by stating that although it would welcome the opportunity to discuss the evidence or its case, it was ethically prohibited from inquiring into the substance of the jury's deliberations and could not promise confidentiality, as it might be required to disclose any such communications to the defendant or the court. And that's crap, because there had already been, well, first of all, they don't even say, they don't give a date on this, right? They're very, very careful. And we talk about this a lot. Lawyers are very careful in choosing their words. Very careful, because words matter. What they don't say is oftentimes, and sometimes when we're watching a press conference by a district attorney like Ray Tierney, sometimes what they don't say is even more important than what they do say, right? Notice how they do not say ever when those emails were received by the Commonwealth, when they were sent by these other 3 jurors, when they were received, when they responded. There are no dates on this. Okay? All we know is that it was sometime prior to August 1st. We don't know if they received these emails the day after the verdict, like as such, when the defense attorney started receiving calls from jurors or communications from jurors. We don't know. Could have been right after the verdict. But the Commonwealth is admitting that they heard from at least 3 or 4 jurors, assuming that the person who left the voicemails was a different juror. It would be 4 jurors. If it was one of the jurors who also sent an email, it would be 3 jurors. But at the very least, 25% of the jury reached out to the Commonwealth. But they are very careful not to say when those emails were received, when they had responded to them, because the order impounding the names of the jurors was signed by the judge on July 8th. So they could have promised them confidentiality because the list of jurors had been sealed by July 8th, depending on when they reached out. All three individuals declined to communicate further with the Commonwealth and provided no information about the jury's purported votes. I want to know when they received those emails. I would love it if one of the appellate judges on the panel comes out and asks them that question in open court during arguments. When did you receive those emails? I notice here that your papers are devoid of any date that these communications were received by these jurors. When was that? And when did you reply to them that you could not guarantee them any confidentiality? What was the date on those emails? And can you produce those emails? Love to see them. On August 5th, Attorney Yannetti submitted a supplemental affidavit stating that he had received an unsolicited phone call on July 31st. The caller said that they had been a juror in the case, and based on what they represented to Attorney Yannetti to be their full name, Attorney Yannetti stated he was able to confirm that the caller was the person identified as Juror B in his prior affidavit. According to him, the caller said the jury had reached unanimous not guilty verdicts on indictments 1 and 3 and had been deadlocked only on indictment 2. The caller also said that they were familiar with Attorney Yannetti's prior affidavit, and the text message exchange referenced in paragraph 4 of the affidavit, quoted above, was accurate, except that they had meant to write, quote, "No one thought she hit him on purpose or even knew that she had hit him." The caller believed that other jurors had been reluctant to come forward because there is so much public and media attention focused on this case. Let's go to the chat for a second before we get into the next section. Thanks, Amy, in Boston, for being here for 11 months. Wow, you're an OG. Buzzing for Truth is excited to see me again today. Thank you so much. I appreciate you, super chat. Hi, Charlie Lynn. Thank you for your super chat. The last mistrial, she read the note, told them that what she was going to do, called upon both sides to speak at sidebar. This is a deviation for her. Are you talking about the Chesna trial? That's interesting. Thank you, Charlie Lynn, for the 10. C, juror privacy and safety concerns. On July 8th, the same day the defendant filed her motion to dismiss, the trial judge sua sponte issued an order impounding the list of names of the impaneled jurors. The judge noted that the case had garnered significant and divisive attention in Massachusetts and across the nation, and that the proceedings continued to be the daily subject of commentary on various social media platforms. Okay, sua sponte means there was no motion in front of her. She did that on her own. The judge noted that the case had garnered significant and divisive attention in Massachusetts and across the nation, and that the proceedings continued to be the daily subject of commentary on various social media platforms. Hey, what's up? She noted, too, that people associated with the case have been charged with intimidation. Yeah. She found that there was a real and present risk of personal harm to the jurors and to the integrity of their service if their names were to be made available to the public at that time, and thus a risk of immediate and irreparable injury, establishing good cause to impound the list. The order stated that it would expire 10 days from its issuance unless otherwise ordered by the court for good cause shown. Do you guys want to look at that order of impoundment? Because I have it right here in the appendix. Perhaps some of you have not seen it. Yeah. Dana says, for someone who gives open court jury instructions, she does a lot at sidebar. Talking about the cert report. Yep, great question about the dates received. I'm not familiar enough with the Chesna case to to comment on it, but little Cupcake says the ACLU is just grifting. just grifting, or they were paid by the defense, right? And they were made very clear in their papers they're not paid by anybody. They're not even a for-profit organization. Exactly, David. The ACLU doesn't grift. Yeah, that was a joke. That was a joke. I know little cupcake snark when I hear it. Good citizen Betterow is sending out a letter concerning Aiden soon today. Oh my gosh. Well, guys, if it comes out, send it to me. You know, I'll just go live and do it with you. I thought it was not ending until she ended it. Correct. You're correct. What did they say here? The order stated that it would expire 10 days unless otherwise ordered by the court for good cause shown. All right, let's take a look at it. Here's that order of impoundment. We did go over it when it dropped, but we're doing it again because it's part of this record on appeal. The Supreme Judicial Court has recognized that the safety of jurors is crucial to the fair functioning of the judicial system, and that the justice system owes them the highest degree of vigilance for their personal safety. This case has garnered, I'm going to make this a little bit bigger, significant and divisive attention in Massachusetts and across the nation. The trial was live streamed on local and national broadcasting channels. The proceedings continue to be the daily subject of commentary on various social media platforms. People associated with the case have been charged with intimidation. The court acknowledges that the names of impaneled jurors who rendered a verdict in the criminal case must be retained in the court file and made available to the public. The jury in this case did not render a verdict. However, the court concludes that there is a real and present risk of personal harm to the jurors and to the integrity of their service. Consequently, the court finds that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. The court further concludes that there is a risk of immediate and irreparable injury should the list be made available to the public at this time. See the Uniform Rules of Impoundment Procedure Rule 3A. This order shall expire 10 days from the date of issuance unless otherwise ordered by the court for good cause shown pursuant to Rule 3B of the Uniform Rules of Impoundment Procedure. XOXO. Beverly J. Canone, dated July 8th, 2024. Right. And then I think what happened was, this is a cold read for me. I have not read this brief with you yet, but I do recall that a juror came with counsel and made a motion to extend that 10-day period, citing some crazy old tweets and such things like that. Let's see if they talk about it in the brief. We'll see. We're getting there. This is not a fly on your screen, by the way. It's my cursor. Please don't smash your TV and send me a bill. On July 18th, one of the deliberating jurors, represented by counsel and proceeding under the pseudonym Juror Doe, filed an emergency motion for an indefinite extension of the impoundment order. The motion was supported by an affidavit from Juror Doe. Juror Doe averred that they feared for their personal safety and the safety of their family if the jurors' names were made public. In addition to the conduct noted in the impoundment order, Juror Doe recalled trial testimony from at least one witness who had described herself and her family being harassed because of her involvement in this case. At least one witness, yes, at least one. I can name 3 off the top of my head that brought it up organically, because remember, the judge said it wasn't going to come in. The witness intimidation was not going to come in unless and until, if any, unless and until, if any, witness mentioned it organically, or just, just brought it up organically. And we did hear it from not only Jennifer McCabe, but also her daughter, Allie McCabe, and Colin Albert. At least those 3 witnesses, as I recall at this moment sitting here today. Juror Doe also stated that, that during deliberations, the jurors could hear protesters outside screaming and yelling. And after the jurors were discharged and transported by bus back to what was supposed to be a secret location, They were met there by what appeared to be members of the media, including photographers. Juror Doe cited recent examples of news articles and social media commentary in which individuals had expressed anger at the jurors, sought to identify the jurors, and advocated publicizing the jurors' home addresses, occupations, and other identifying information to harass and shame them. In closing, Juror Doe said, "My affidavit and motion should not be interpreted as indicating how I or any other juror voted on this case, or how I or any other juror feel about this case. Every member of the jury, regardless of how they voted, is likely to face backlash from a segment of the large portion of the public who intensely followed this case. I wish to remain anonymous, and I bring this motion on behalf of myself and any other juror who does not wish to be identified, regardless of whether or not we agreed during our deliberations. It was an honor to serve on the jury. It also was a significant sacrifice of time, which I understood and anticipated when I was selected. What I did not anticipate, however, was the likelihood that I and other members of the jury would become targets of intense public scrutiny and likely harassment campaigns strictly due to the outcome of our private deliberations. If jury names are made public, I will be subject to nonstop requests for comment about jury deliberations. I would prefer to not have to respond to these inquiries. However, what I fear is not only will I be subject to requests for interviews, but that I will be targeted and harassed because of what I did or did not do on that jury. I fear that verbal harassment will likely lead to physical confrontation and physical harm. I am not prepared or equipped to participate and prepare for any surprise personal attack. More importantly, I fear that I will not be able to protect myself and my family." Let's go to the quote. Let's go to the chat for a second. Hi, Irene Kelly. Thanks for being here for 3 months and sending love from the UK. My mods are the best on YouTube, as is this chat. Karen, thanks for tuning in from Canada and for the super chat. In my personal opinion, Judge Bev was hell-bent on putting Karen in jail to protect the town bully and associates. Thank you for sharing your opinion, Karen. This is a good time to point out that the opinions of my viewers are not my opinions. Nothing said herein or is deemed to be legal advice in any way, shape, or form. Thank you so much for that. The trial judge credited Juror Doe's affidavit and found that Juror Doe had established good cause to extend the impoundment order unless and until otherwise ordered by the court. Here's a summary of the argument. Yeah, well, let's just point this out because Galera and I discussed this the other night on his show, that the foreman was doxxed apparently by someone on Twitter or X, or I'm going to call it Twitter forever, so just cry about it. The jury foreman was apparently doxxed by someone on Twitter who posted apparently what seems to be or may be or may not be. I cannot confirm or deny because I have no idea who the foreman was. That person's LinkedIn profile. And it's important to point out that the public is not bound by this impoundment order. This impoundment order applies to the parties in the case, not the public. So I don't know who did it. I think it was a horrible thing to do. And I don't know if Juror Doe is the foreman of the jury. And usually the attorney drafts the client's affidavit. But I will say, just from hearing the cadence, tone, language of this affidavit, sounds a lot to me the way the juror notes sounded. So if I had to venture a guess, I would say that this might be the foreman, just based on the language alone and based on the language of those juror notes that we just read and looked at together. So Kim says, why are we hiding the jury foreman? It's been published in the media about him being a cop and was in an auto accident. That I don't know. I don't know what media, independent media, mainstream media. I don't know. Don't be hating says that's a leap in logic from words without violence to physical violence. Yep. Somebody said the person that doxed this juror was trolling on Alexa's room. Really? Lisa Lee says, I bet the DNA of everyone involved was under John's fingernails, but no one collected it. How about all the unknown contributors of the DNA found on John's clothing that also was never tested or compared? Weren't there at least 2 or 3 unknown contributors to the bloodstains on John's clothing that were never tested or identified? Scott McGinnis, hello. Name any violence perpetrated or threatened by anyone. Free Karen Reed. I can't. Unless they're pointing to Aiden Carney. I don't know. I mean, I think that's what they're trying to say. But what say you? So obvious this is full of fakakta. Yeah, it's fakakta. It's fakakta is right. Thanks, Buzzing for Truth. Right. And then Grant Smith Ellis confirmed it. I don't know. I don't know who did what because I'm not on the Twitter, as you know. They chased me off of Twitter when they came for me at the beginning of my covering of this case. And that's been, pretty much the MO of anybody who thinks that Karen Reed is guilty and should be hung in town square, that they will try and threaten, harass, dox anybody, especially from the beginning, who was speaking out about how, in my opinion, with 30 years of legal experience in state and federal courts, handling all kinds of things, not just the sex abuse cases against the Catholic Church, but also all kinds of accidents, construction accidents, plane crashes, trains crashes, dog bites, and pedestrian cases, that in my experience, the injuries that were sustained by police officer John O'Keefe are not the injuries that are sustained in a pedestrian versus motor vehicle accident. They're just not, especially not at 24 miles an hour. Anybody who knows anybody who is ever hit by a car as a pedestrian can just use their common sense on that. But that was the MO. All of these people out there who wanted to shut me and other people up. Didn't work. I'm still here talking about it. The trial judge credited Juror Doe's affidavit and found that Juror Doe had established good cause to extend the impoundment order unless and until otherwise ordered by the court. And here's the summary of the argument with footnote 4. Right. How does vomit get on his shirt? Good point. Footnote number 4. The Commonwealth addresses first the defendant's arguments concerning the mistrial before turning to the supposed acquittals. That was the order in which the issues arose before the trial judge. Moreover, the defendant attempts to use the purported juror statements in hindsight to challenge the necessity of a mistrial, even though those alleged statements were unknown to the judge and the parties at the time of the mistrial and could not have factored into the judge's exercise of her discretion. Yeah, because she didn't ask. And as we went over yesterday, as pointed out in the lovely brief filed by the ACLU of Massachusetts, she has the discretion to ask, and she didn't do it. Which begs the question, does everybody here just want a conviction, or do we really want justice and the truth? It's a rhetorical question. Summary of argument. The trial judge soundly exercised her discretion in declaring a mistrial on the ground of manifest necessity. The jury repeatedly reported it was deadlocked and further stated that continuing to deliberate would be futile and only forced the jurors to compromise their deeply held beliefs. The jury gave no indication it had reached a unanimous verdict on any charge, and the defendant argued at the time against finding any such unanimity. There was no viable alternative to a mistrial, but even so, the defendant was afforded a meaningful opportunity to be heard on any purported alternative. Oh, wait, here's a good emoji for that. Nope. Even assuming there was no manifest necessity, the trial judge properly ruled that the defendant consented to the mistrial. The possibility of a mistrial because of deadlock was clear from the jury's first note and clearer still from its second note. Defense counsel consistently pushed for that result in response to those notes, had ample time to prepare for a mistrial before it was later decided or declared, and raised no objection despite multiple opportunities to do so. The defendant's personal assent to the mistrial was not required. Here we are, trampling all over your rights. Here we come. We're trampling. Defendant's personal assent to the mistrial is not required. Who's got the right? Who's got the constitutional right to not be tried twice for the same crime? Is it the defendant herself or is it her attorneys? This argument fails for more than one reason, but one reason is because just because her attorneys agreed prior, doesn't mean that they would have agreed the third time or whatever this is. And she gave nobody the opportunity to speak. She just said, I am not going to do this to you. I am declaring a mistrial. I will come back and talk to you in a minute. That was it. She did not say, I'd like to hear from counsel. She did not say before the jury even came in, the jury's at an impasse. Does anybody want to say anything? What should we do here? There was no collaboration whatsoever. And I think the ACLU brief makes a lot of really good points, going all the way back to, in some points of their arguments, the rule of law from the 1600s in Massachusetts. And that the right against double jeopardy is rooted in Massachusetts. Crazy. Somebody said yesterday in chat, interesting that Massachusetts is both the birth and death of double jeopardy. Give me 1 second. Okay. The defendant was not acquitted of any charge because the jury did not return, announce, and affirm any open and public verdicts of acquittal. That requirement is not a mere formalism, ministerial act, or empty technicality. It is a fundamental safeguard that ensures no juror's position is mistaken, misrepresented, or coerced by other jurors. It also protects each juror's right to rethink their position and to change their vote before reaching a final verdict. The alleged post-trial statements from certain purported jurors do not constitute acquittals, and the judge properly denied the defendant's request for a post-trial inquiry of the jurors. That inquiry would necessarily require delving into the jury's deliberations, which this court has consistently and firmly held impermissible. I mean, I don't know how much how much more snark I can even apply here, but asking a simple question of yes or no, are you deadlocked on all three charges, is not delving into their deliberations. It's just not. It sounds like we're splitting hairs here, which oftentimes when it comes to case law, we are splitting hairs here. And we need to, because we have constitutional rights at issue here, in my opinion. Argument. Roman 1, the judge soundly exercised her discretion in declaring a mistrial where the jury reportedly reported it was deadlocked, gave no indication of unanimity on any charge, and stated that further deliberations would be futile. Double jeopardy principles do not bar retrying a defendant when a mistrial is declared as a matter of manifest necessity. A deadlocked jury is the prototypical example of a manifest necessity justifying declaration of a mistrial. On review, the question for decision is whether the petitioner has shown an abuse of discretion by the trial judge in declaring a mistrial. These are just quoting other cases. This court accords great deference to the trial judge's determination when a mistrial is premised upon the trial judge's belief that the jury is unable to reach a verdict. The propriety of a deadlock-based mistrial is not answered by application of a mechanical formula. It is a circumstantial inquiry, and the pertinent factors correspond to those informing whether the jury has conducted due and thorough deliberations. That's right, on a case-by-case basis. These factors include the time spent deliberating relative to the length of the trial, the complexity of the disputed factual issues, and statements by the jury that they cannot agree. Here, after deliberating across 4 days, the jury told the judge it had exhaustively reviewed the evidence and diligently considered all disputed evidence, but had been unable to reach a unanimous verdict. Considering the jury's note, the extent of deliberations thus far, in view of the trial length, the amount of evidence presented, and the complexity of the issues to be decided, the judge found the jury's deliberations had not yet been due and thorough, and she instructed the jury to continue deliberating. On the next day of deliberations, the jury sent the judge a second note, stating in stronger terms, "We find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions, and consensus is unattainable." Considering again the jury's statements and the additional time spent deliberating, the judge found the jury had conducted due and thorough deliberation and provided the Tui Rodriguez charge. Footnote 5, which says, giving into a Tui Rodriguez instruction is the orthodox approach to dealing with a deadlocked jury, and ordinarily the preferable course. It encourages the jury to consider seriously and with an open mind the views and arguments of each member. In some other states, it's called an Allen charge. It's basically like I don't know, for lack of a better term, like a little pep talk to the jury, like, "Here you go, jury. Listen, jury, we know you say you're deadlocked, but listen, there's no other jury in the world that's going to be able to decide this case better than you can. You've given it such a great college try so far. Just get in there one more time and give it the old college try again, and listen to each other and listen to each other and listen to the other points of view and see if you can come to some sort of consensus." Sort of like a last clear chance sort of charge. Later that afternoon, the jurors returned a third and even more emphatic note that said, "We continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided, stemming from a sincere adherence to our individual principles and moral convictions, and further deliberations would be futile and only serve to force us to compromise these deeply held beliefs." The judge, quote, "had no doubt, based upon the jury's notes to the court, that it was unable to reach a unanimous verdict. It was also, quote, clear to her from the third note that the jurors would not consent to continuing their deliberations." See the record on at page 268, telling the jurors, quote, "I'm not going to do that to you folks." At that point, the jurors could not be compelled to continue deliberating without their consent. In short, the judge's declaration of a mistrial due to deadlock was informed by her consideration and weighing of the specific factors pertinent to that decision. She did not abuse her discretion. The defendant nonetheless claims the judge erred by failing to consider alternatives to a mistrial and to give defense counsel an opportunity to be heard. As to purported alternatives, she contends the judge should have inquired whether the jury had reached a unanimous verdict on any charge or asked the jurors if they would consent to further deliberations. The judge was not obligated to make either inquiry as a matter of course. Citing Fuentes, which says judge under no duty to inquire about possibility of unanimous verdicts or willingness to continue deliberating. See Bluford, rejecting argument that judge needed to give effect to any potential unanimity on charges before declaring a mistrial because of hung jury. And Daniels, which says judge not required to receive partial verdicts. And Commonwealth v. Floyd, judge has discretion as to partial verdicts. That's the key here. The key is judicial discretion, in my opinion. The judge had the discretion to ask them if they were deadlocked on all charges, and she just didn't do it. And even after being presented with all kinds of proof really from both sides, the Commonwealth admitted they received emails and voicemails from jurors who said that they had acquitted on 1 and 3. Even after receiving all of that evidence and taking it all as true, she still decided not to call the jury back and ask them the simple question, yes or no. And she has the discretion to do so. So I could hammer that point home a little bit more, but I feel like I'm, again, screaming into a closet. The circumstances before the judge also did not necessitate either inquiry. There was no reason for the judge to ask if the jurors would consent to further deliberations. The jurors' final note made it abundantly clear that they did not consent, and that if they continued to deliberate, any verdicts reached would not have been each juror's own verdict, the result of their own convictions, but rather a mere acquiescence in the conclusions of the other jurors. Citing Arizona case, just as Arizona, trial judge best positioned to assess whether jury able to reach just verdict if deliberations continue. There was also no basis for the judge to inquire whether the jury had reached a unanimous verdict on any charge. Nothing in the jury's 3 notes indicated agreement on any of the charges, or even an inkling of an indication of agreement. Again, I'm going to go back to the jury instructions where she said, do not report back to the court, do not fill out any of the papers until you have reached unanimity on all of the charges. To the contrary, the first note said the jury had been unable to reach a unanimous verdict, declaring outright that the jury had not reached a unanimous decision on any charge. Second note stated consensus is unattainable, which would be a peculiar way of describing the jury's deadlock if consensus had in fact be attained on any charge. Period. The third and final note, returned after the Tui Rodriguez instruction, stated the jury remained at an impasse on the charges and not just a particular charge. Okay. But again, count 2 contained multiple charges. A little bit louder for those in the back. Count 2 contained multiple lesser included charges, plural. As the judge found, the only reasonable interpretation of these notes, and specifically the final note, was that the jury could not agree on any of the 3 charges and further deliberations would serve no purpose. Cifuentes, when final jury note unequivocally stated jury was deadlocked, judge properly declared a mistrial without inquiring into possibility of unanimous verdicts or whether jury would consent to further deliberations. Commonwealth v. Ross, improper to assume there is any final verdict lurking within that deadlock that may be extracted. Many of the cases that they have cited throughout the course of this issue have been cases where there was only one charge on the verdict slip. So it's important to distinguish that. Moreover, the judge was mindful of this court's repeated admonitions that deadlocked juries are particularly susceptible to coercion. The jurors in this case had reported 3 times that they were unable to reach agreement and had been given Tui Rodriguez. In these circumstances, a judge's inquiry concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something from the trial. The jurors also had been instructed on lesser included offenses. Citing Roth, which says judge precluded from initiating any inquiry into partial verdicts premised on lesser included offenses due to heightened risk of coercion. The judge recognized that even asking the jurors if they were truly deadlocked, let alone probing on which charges they were deadlocked, would have been coercive. That's a stretch. Citing a case that says such questioning would have implied to the jurors that the court wanted them to resume deliberations to reach a verdict. Judge interacts directly with the jurors while presiding a trial and thus is ordinarily in the best position to assess potential for coercion. Roth, in many instances, asking a deadlocked jury about partial verdicts would constitute attempting to extract from the jury something that does not exist. Note 6. The defendant relies on Commonwealth v. Foster and Commonwealth v. LaFontaine to argue that there is nothing coercive about asking a deadlocked jury whether it has reached a unanimous verdict on any charge. Those cases are inopposite because neither of those juries reported being deadlocked. The judge further recognized that to make such an inquiry on her own accord could impede upon the strategic decision of counsel to not make such a request. Given that defense counsel had previously accused her of directing a verdict on the lesser included offenses because of how the OUI manslaughter verdict slip was initially worded. What? She was all the more attentive to avoiding pressuring the jury. Okay, now you're inside the judge's head. Now you're inside the judge's head. Here's a little dig. Here's a little poke in the bear. Given that defense counsel had previously accused her of directing a verdict on the lesser included offenses because of how the OUI manslaughter verdict slip was initially worded. She was all the more attentive to avoid pressuring the jury. Let's talk about that for a second, shall we? Remember all the way back when they were discussing the jury slips? And, that's not the way we do it in Massachusetts, Mr. Jackson. And, Mr. Yannetti, you've seen a verdict slip like this before, haven't you? And I said, well, no, Your Honor, actually, I haven't. Oh, really? Have you never had a case with any lesser includeds in it? He's like, no, I have, Your Honor, except this isn't the way it is. We need a not guilty box. And then she said something like as to the effect of, oh, well, it's obvious. If they just don't check the guilty box, then it's not guilty. Do you remember that? And then she went out, had a little timeout. And then when she came back, she put it on the record that she did change it. And she wanted everyone to admit on the record now that they were happy with it, that she did a good job. You guys remember that? Hey, Mazza. Good afternoon, Mazza. You guys remember? Remember when she did that? And then in the end, she didn't admit that she agreed with Alan Jackson and David Yannetti, but she did allegedly change the verdict slip. We've never really seen the final verdict slips. I don't think. Exactly, says Nancy. They didn't listen to his very strong opposition. She cut him off. And then Robbie says, but she never changed it. And BM Esquire says, lots of big accusations coming out of this brief. Mm-hmm. Mm-hmm. Buttering up Judge Cannoni in case it goes back to her, saying that she was all the more attentive to avoid pressuring the jury. She didn't want to pressure the jury. Yes, it's the absence of the not guilty box, Danielle. Hi, Danielle. How are you? Always good to see you here. Gail Taylor said, really hoping for common sense to prevail. Bev should have met with the jurors. The continued BS from the Commonwealth and the judge's lack of attempt to put this right. I asked myself, why are they gunning for Karen Reed? That's such a great question. Such a great question. And here comes Auntie Bev's verdict form for the win. We're just talking about that, and here you are. Thanks for the super chat. Running at 1.75 speed to catch up to Melanie's live stream is like running uphill. It's a steep learning curve and so worth it. Thank you, Melanie Mods. Thank you, Auntie Bev's verdict form. And for the love of everything holy and the traveling Mary and for God saving the Commonwealth, can you tell us if the verdict form was really ever changed? And also, I talk so fast to begin with that I can't imagine what I sound like on 1.75 speed. I'm going to sound like the chipmunks. Thank you, Sage Henning, for your super chat. We learned through Turtle Boy's interview that the jury came up with their own theories on what happened. Isn't it the jury's job to listen to evidence and decide if it was proved by the Commonwealth? Yes. Not play detective? Yes. And I will say also, we've talked about this before. Each side only had 1 hour for closings, right? Ridiculous. What do they say in this brief? That there was 37 days of testimony? And something like there were 74 witnesses and 657 exhibits. How in the name of the Commonwealth is 1 hour, 60 minutes sufficient for any trial attorney, including the greatest trial attorney on the planet, to be able to cover everything that happened during the testimony of 74 witnesses and 657 exhibits? It's virtually impossible. And one thing that I might have hammered home on, if this was my closing argument, would be reasonable doubt. And if you are back there thinking of other ways that this could have happened, of other ways that they couldn't even call him Officer O'Keefe, John O'Keefe died, that is reasonable doubt. That is reasonable doubt. They had so much to cover in 1 hour that it was virtually impossible. But yes, you are exactly correct in your assessment, Sage. Excellent, excellent assessment. I'm going to allow it. Became a new member. I'll allow it. And then gives a $10 super sticker. Thank you. Welcome, welcome. Hello, Suze. May I state that you cannot prove manifest necessity of a mistrial when the judge never asked if they had come to agreement on any counts. It was approximately 20 hours for 9 weeks. 20 hours of deliberations for 9 weeks. Yep, 37 days. And I think, based on the fact that they came out the next day to say that they had acquitted on counts 1 and 3, that when she said, "I'll be back to talk to you in a minute," maybe some of the jurors thought, okay, she's going to now come back and ask us if we had acquitted on any of the charges. But she didn't. And didn't one of the jurors say that, yeah, we were on the bus going back to our secret parking lot and we were all confused. Like, why did nobody ask us if we acquitted on any of the charges? Agreed. Thanks for the 10. YouTube turns. Seems like this was staged by Bev from the beginning with the little thinking emoji. Has Bev done this in previous trials? I don't know. This is the first trial of hers that I've covered, but I am covering 2 more that are coming up. One is the Brian Walsh case, which has all the same players in it. Michael Proctor, Chuparino, and company. Sandra Birchmore will be, that's in federal court. But the other case is Dr. Ingolf Turk, who was accused of murdering his wife and putting rocks in her yoga pants and then putting her in a pond behind his property. And that case is also in front of Judge Cannone, as is the Walsh case. And what's very interesting is that the same players in the MSP investigated each one of those cases. So I don't know about her previous trials, but maybe some other people in the chat can help you out with that. Although it was just pointed out that during her last mistrial, she did speak to the attorneys, I guess, before declaring it and call a sidebar. Hi, Dewey. Didn't Cannone show her bias when she said something about no shrinking violets regarding Jackson and Unity? In my opinion, yeah. Yeah, in my opinion. That was a diss. Yeah, they were no shrinking violets, so they would have said something if they wanted to, because they called me out at every other opportunity that they had, which is not exactly what she said, but shrinking violets, I think, speaks for itself, right? Hi, Camille. Thanks for your 5. I believe the Commonwealth is backpedaling desperately, realizing they really foobarred it. Thanks, Camille, for your 5 and for your opinion. Susie Q. Welcome, Susie Q. Romy. Thanks, Romy. Thanks for the 20. People in my non-online life that believes Karen Reed hit John O'Keefe agree she was overcharged. Morrissey digging his heels in with charges 1 and 3 isn't a good look, in my opinion. I hope this makes sense. I'm in the school pickup line and typing fast. Don't be that mom that holds up the pickup line. Oh my gosh, what was that show where that pickup line was always such a big, I'll think of it. It'll come to me. If you guys can think of it, let me know. They always had such drama in the pickup line, and I can't remember the show right now. It was a series. Thanks, Romy. Yuri's math teacher, gifting 5 memberships. Always so kind and generous to this channel, and I love you and appreciate you so very much. Tracy V became a member, and congratulations to at least the 5 that were gifted memberships. Tracy, for coming in hot. Hi, Sage. Another one. Sage with another 10. Whose fault is it then that the jury failed her? The judge for her awful instructions? I cannot wrap my head around how they understood Trooper Paul with key cycles, but not that they don't come up with theories. Whose fault is it then that the jury failed her, meaning Karen? The judge for her awful instruction. I mean, listen, there is I could sit here for 3 days and talk about this with you. The instructions were confusing. There was a simple fix to this, and the simple fix would have been to ask the jury if they were deadlocked on all 3 charges. She didn't want to do that. There was another fix where she could have said, okay, attorneys, do you have anything to say before I declare a mistrial? I'm about to declare a mistrial. Do you want to make any arguments? Do you have anything to say about it? After declaring a mistrial, she could have asked the attorneys if they wanted to poll the jury. There's a lot of things that could have been done that weren't done. And there's been so many opportunities to clean this up. But the judge has not taken any opportunity to do so. She had the opportunity to walk away from this case during the pretrial when, if you haven't seen the pretrial motions, I have an entire playlist on them. When she was asked to recuse herself, and there were things pointed out during that motion that she may have some relationships with some players in this case, and or just the appearance of impropriety based on some Venmo transactions. And she had the opportunity at that point to say, look, I don't know any of these people. I don't know the Alberts. I don't know the McCabe's. I never rented my beach house to anybody. I have no idea what this Venmo is from Julie Nagel to Ryan Nagel that says for Frank and Beverly on it. That's not the way I spell Beverly, by the way. That's what she did say. But just to avoid the appearance of impropriety, I'm going to recuse myself and I'm going to hand this over to another judge. She had that opportunity. And it's been reported also that she's been transferred to civil court. So how she still has, a tight rein around the Walsh case and the Turk case, I have no idea. I don't know what's going up there in Norfolk County. For duck's sake, thanks for gifting a membership. I love your little emoji too. You guys with all your rubber duck emojis. I mean, Sage, it's like crazy. It's crazy. Thank you for duck's sake. That's when she scolded Karen. That's right, Kelly, Carolyn. Something funny, Ms. Reed? Something funny, Ms. Reed? She was tired, says Belinda. She was tired. That's right. When it came to the jury, the verdict slip, she was tired. Because when they tried to point it out to her and they said, Judge, you said you were going to do this and that you were tired. I remember. Good afternoon to everyone who's just joining us. Look, there's over 3,000 people in here on a whatever afternoon this is. Did we decide what afternoon this is? It's Thursday, October 17th. And there's over 3,000 of you in here, but looks like there's only, oh, that can't be right. 1,200 likes. Come on, you guys got to get that like number up, or I will turn off the air conditioning. I will turn off the air conditioning. You will be stuck with the fan. And that's not the way that we do things in Cupcake Nation. So let's smash the like button. I promise you, Canton PD nor MSP will get a hold of your DNA. Right, Scott? All right. So Mark supposedly dropped part 3 of the Better Row letters. Where are they? Where are they? Also, special thank you to Melinda and to Jonathan. Hmm. You mean the Better letter has dropped as in it's out there? Or it's been filed with the court? What? Anyone? Anyone? Oh, yes. Oh, yes. Oh, yes. Bang, bang, the like button. Bang, bang. Bang, bang. Bang, bang. Bang, bang. My friend is a judge in Plymouth County and says that Bev is a lovely lady and he really likes her. I will say, Tracy, that when I was in the courtroom, the one day that I did go to court, and Mark Bettero and I went the same day, which was the day that she shut off the cameras because there was a juror caught on camera. I found her in person to be far more friendly, and her vibe was very friendly as well. I agree. And I did. I said that a lot. I found her to be much more friendly in person than she came across over a screen. And then Scott says, but watch Bev in her other trials. She's always so proud. Defendant. It's weird to see her actions in the Karen retrial. Yes. When we watched that hearing, because last time we watched Aiden Carney's hearing, the was it Turk or Walsh that came in after that? And she came on the bench and I saw her walking into the courtroom and I said, oh my God, we got to cover this hearing too. And we did. And she was so kind to Brian Walsh. I think it was Brian Walsh. So kind to him. And this guy's accused of chopping up his wife into little pieces and like distributing her remains in dumpsters all over town. And Googling such things as, how to dismember a body, how to, what chemicals take blood out of wood and concrete floors and things like that. All right. Turning off the AC. I'm not going to turn off the AC. You're going to hit the like button and you're going to like it, Connie. Thanks. Elf, has this ever happened in our history with a jury? I would have spoken up. We see it in a couple of other cases. We're seeing it in the Ashley Benefield case, where it's coming out that one of the jurors may have lied on their jury questionnaire forms about being a victim and a survivor of domestic violence, and the case was about domestic violence. But the difference there is that there was a conviction in that case. And so if that juror did lie, that could be grounds for a new trial. There's already a mistrial here. So the idea is to get the judge to poll the jury and then perhaps agree that there was an acquittal on charges 1 and 3. Is it going to happen? I don't know. The chances could be slim and none, and maybe Slim just got on the bus. Like, I don't know. Veith Kilbert, finally progress update on the appeal. That was a long, long time. Hopefully the Supreme Court will rule soon. I don't know what we're talking about. It's on Turtle Point News. Bang, 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 bang. Oh, it's been filed. Okay. All right. Okay. If anybody has it, they can send it to me. I'm going to put my my email up here. There you go. Just remember, I can't be your pen pal. I can't deposit money into your commissary account. And I cannot, absolutely cannot go pick your 5-year-old up in Kentucky and buy them a plane ticket and fly them to see you in South America, even if you promise me 20 acres of land. Okay. Thank you. Fanbase at mlittlelaw.com. Okay. So after that little snarky comment about how she was all the more attentive to avoiding pressuring the jury, far from failing to consider an inquiry into the nature or extent of the jury's deadlock as an alternative to a mistrial, the judge was acutely aware of the concerns that would have made such an inquiry improper under the circumstances. Nor was defense counsel denied a meaningful opportunity to be heard. In response to the jury's first note, counsel disagreed with the prosecutor's characterization that the note left open the possibility the jury might yet achieve unanimity. Counsel argued that the note could only mean that the jury had already exhausted all manners of compromise, all manner of persuasion, was at an impasse, and should be given the Tui Rodriguez instruction. He did not ask the judge to inquire of the jurors what they meant when they said, "We have been unable to reach a unanimous verdict," or whether they had reached verdicts on some but not all charges. With the jury's second note, counsel argued the jury have come back now twice, indicating essentially that they are hopelessly deadlocked. Leveraging the language in the note, he emphasized that the jurors had fundamental disagreements about what the evidence means and it's a matter of opinion. It's not a matter of lack of understanding. He again argued in favor of a finding of due and thorough deliberation and again requested Tui Rodriguez. He exhibited no curiosity at all about the extent of the jury's deadlock and did not ask the judge to inquire the jurors. No curiosity at all. I'm just getting curiouser and curiouser. Call me Alice. That's why you see Alice up there. Fall into lots of rabbit holes. The defendant now claims that her attorneys, by repeatedly requesting the Tui Rodriguez instruction, were merely trying to encourage the jury to reach unanimous verdicts. In reality, and as the judge found, counsel were pushing for the result of a mistrial, knowing that the judge would not declare one until the instruction had been given, and that if after the instruction the jury returned deadlock again, would be triggered. GL, General Law 234A, Section 68C would be triggered, and a mistrial would be all but inevitable. When the jury sent its third and final note, because, third time's a charm, the judge informed counsel in open court while waiting for the jurors to enter the room, the jury is at an impasse. Counsel could not credibly have believed that the result of that note would be anything other than the mistrial for which they had consistently pushed. They could have said it strains credulity, but this time they didn't. And it can fairly be inferred from counsel's silence as the judge read the note aloud and declared a mistrial The counsel neither objected to the mistrial nor would have suggested any alternative. This looks like it's the court's ruling, quoted here. The court finds it hard to believe that when counsel heard that the jury was at an impasse for a third time and a mistrial was inevitable, at perhaps the most crucial point in the trial, counsel would sit silently as if they did not consent to a mistrial. Citing some more cases. Even so, counsel still had multiple opportunities to object if they in fact objected. Counsel could have objected or at least asked to be heard on the matter at any point while waiting for the jurors to enter the courtroom after the judge announced the jury remained at an impasse. During the subsequent discussions with the judge about scheduling a status hearing, or while the jurors were still at the courthouse and waiting in the deliberation room for the judge to speak to them. And they are citing a case called Fuentes, which they say stands for the premise that counsel objected to mistrial after the jury was dismissed. Judge then heard from both parties and recessed case. Had defense counsel raised an objection, they would have been heard. The judge made a point to note that counsel were no shrinking violets. There it is. There it is. No shrinking violets. That they had never needed the judge to inquire whether they had an objection in order to be heard. Write that down. And she had never refused them an opportunity to be heard in open court or at a sidebar. Despite several opportunities to do so, counsel raised no objection to the mistrial. Instead, counsel said nothing about the mistrial to the judge, and after engaging in a scheduling conference in open court before the judge, proceeded to gather with the defendant to the courthouse steps, where counsel made statements to the media and onlookers. Another dig. Like, yeah, you can go outside and talk to the press, but you can't. You're afraid to talk to the judge. Counsel's statements also expressed no objection to or dissatisfaction with the mistrial. Rather, counsel declared the Commonwealth failed miserably and will continue to fail. For these reasons, the judge found not credible. Oh, and that's footnote 8. Where it says counsel declared the Commonwealth failed miserably and will continue to fail. Footnote 8. Oh, all right, hold on. We got to go back to footnote 7. Footnote 7 comes after when they say the judge never refused them an opportunity to be heard in open court or at sidebar. I'm sorry, I skipped footnote 7, which says counsel's objection to the initial version of the OUI manslaughter verdict slip serves as an illustrative example. Counsel accusing judge of directing verdict on lesser included offenses and telling her, I don't really care how it always is in Massachusetts. I'd like an answer from the court, and that's not how it should be, and it's over our strong objection. I love that this is in the appellate record. I love that. I love that. Footnote 8 comes after the sentence. Rather, counsel declared the Commonwealth, quote, failed miserably and will continue to fail. Footnote 8, a video of counsel's statements is available at the following link, cited by the judge in her order. Okay, we're going to have to watch it because I pulled it up, so let's watch it. Let's watch it. It's only 1 minute and 17 seconds, and you know what? This was on July 1st. Thank you, footnote 8, for giving us a welcome break from reading to listen to a video from courthouse steps on July 1st of 2024 after the mistrial was declared, entitled, We Ain't Got No Quit. Ready? Oh, it would help if I would share the screen with you. We have no quit is what they called it on Boston 10. Here it is. Enjoy.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit.
Alan, you're going to stay on?
Go ahead.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is, we ain't got no quit.
We ain't got no
There
quit.
you were hearing from the defense team, both David Yannetti and Alan Jackson, which, by the way, Alan Jackson is based out of Los Angeles. Whether or not he will continue on the case, there was a reporter who yelled that out. We don't know, but we just...
That was never in question, whether or not he would continue on the case. That was never in question. He's not from around here, folks. He's from LA, you know, the shiny, sparkly thing from LA, the slick attorney from LA. Disco Duck, thanks for the Canadian 5. Simple question for truth. Are you all deadlocked on all charges? Why does the Commonwealth avoid the truth? It's a great question. Strains credulity, doesn't it? Amanda Erickson, thanks for hanging in there with me for a month. Tanny, thanks for the 5. I'm more interested in if her husband's name is Frank. It is. It is. And if you remember, I don't know if you watched the pre-trial, but it's in one of the, it was a giant, they call them chalks in Massachusetts. We call them trial exhibits, but it was on like a giant piece of poster board. And Eliza Little held it up during the motions hearing. And it was a Venmo, a screenshot of a Venmo transaction from Julie Nagel to Ryan Nagel. And it said, didn't say how much money, but it said for Frank and Beverly. But Beverly was spelled Beverley. And the judge was quick to point out, that's not how I spell my name. She didn't say, I don't know a Frank, but it is her husband's name, Tanny. So there you go. That's a good reminder to everyone. Set your Venmo transactions to private. Just do that. As a matter of course, you just should. Elf, has this ever happened in our history? We just went over that. Sage, how do we help Karen? Send letters to the Attorney General. You can, there's a link somewhere for the for her defense fund. You can contribute to her defense fund if you choose to do so. It is very, very expensive to fund an appeal. And I think they've raised something like maybe for the appeal over $500,000 already. So thank you for asking. Michelle's Plantry, thank you for becoming a YouTube member. Michael Martin, something is rotten in the state of Massachusetts. Thanks for the deuce. Iceman, I loved that. It's making me smile from ear to ear. Eliza Little looked like a crazy person in the background holding that Venmo sign up. And then remember, she got yelled at. She got yelled at. She's like, put that down, put that down. I don't remember if she said that about the Venmo or about when they showed the picture of John's arm. Can't remember which one that was. But it was one of, she was reprimanded, you know, like, that's not the way we do it here. Right, Magnolia Gypsy, like it matters, like it matters that that's not the way that she spells it. Yeah. Thank you, B Harmony, for sending me 5 matcha lattes. And she says, was listening to you last night. My granddaughter heard you say it was beautiful today. And she responded, yes, it was. Thanks. Hello, B Harmony, to your granddaughter. And I love the fact that children can watch this show and learn about the law because we just started off not using foul language here and you guys seem to appreciate it. And you can listen to me without your headphones at work and with your kids in the room. And you don't have to worry that an F-bomb will be dropped. And I'm not dissing anybody who chooses that for their channel. That's totally fine. It has just been the way my channel has morphed. And it's the way we like to keep it. Sue says we've raised $512,000, $329 to date. Right. True crime addict and Auntie Bev stated to Ms. Little, direct those chalks towards me or I won't allow them. Yep. And no relation between Eliza Little and myself. It's very common. YouTube turned, gifting 5 memberships. Thank you so much. And to all of you who are gifted, thank you. Like, for example, Coffee Cake is very, very thankful. And Don't Hate, let's see. Annie Ruler, Sarah McD, Coffee Cake, Brutally Honest, and Sage Henning was gifted. See, all you got to do is participate in the chat. And look at Sage won herself a membership. So welcome to all 5 of you. All right, back to the papers. Back to the papers. We're almost done. That was a nice little break to watch that video. For these reasons, the judge found not credible the assertions in the defendant's motion that the declaration of the mistrial was sudden and unexpected, or defense counsel's assertion in his affidavit that he lacked an opportunity to be heard. There's no shrink in violence. The defendant cannot overcome those credibility determinations, fully supported by the record, which show the remarkable turnaround in her position post-trial for what it is, a hindsight contrivance based on the purported juror statements. Hindsight's 2020. And then they said a case Commonwealth versus something that I am not even going to try and pronounce. Motion judge not required to accept self-serving assertions in supporting affidavit, even if, unlike here, nothing in the record directly contradicts them. Well, that's interesting to point out because the self-serving assertions were deemed to be completely 100% credible by the judge in her decision. So there's that. Roman 2, the judge properly found the defendant consented to the mistrial where counsel consistently pushed for that result and had several days to prepare for it, and when it was declared did not object despite multiple opportunities to do so. Hold on. A defendant's consent to a mistrial removes any double jeopardy bar to retrial. Such consent may be inferred from silence where a defendant had the opportunity to object and failed to do so. Citing 2 cases there. A defendant's silence in the face of a mistrial declaration has also been held to demonstrate consent when the total situation was such that the defendant could reasonably have anticipated that the issue of a mistrial would arise and could prepare himself for the event. Silence could then be plausibly read as acquiescence. As discussed above, defense counsel consistently sought a mistrial, and when it later transpired, raised no objection. Counsel also had ample time to prepare for that outcome. The jury returned its first note around noon on Friday, June 28th, its second note on the following Monday, July 1st, around 10:45 a.m., and its third and final note around 2:30 p.m. that same day. Counsel had 3 days between the first and second notes and several more hours between the second and third notes to prepare for a possible mistrial and to discuss the matter with the defendant. The defendant cites Horrigan for support, but the total situation here was markedly different than in that case. In Horrigan, on the morning of the second day of trial, the first justice of the district court abruptly and with no prior warning to the parties or counsel walked into the courtroom and announced a mistrial because the trial judge had a medical emergency and could not preside. There, the mistrial was truly sudden and unexpected. Here, it was entirely foreseeable and played out over days. The defendant also argues that her personal assent to the mistrial was required. She did not raise this argument before the trial judge, and it is waived. Roman 3. The defendant was not acquitted of any charge where no verdicts of acquittal were returned, announced, and affirmed by the jurors in open court. This is where they should really be focusing their time and attention, but nobody asked me. As this court had explained in rejecting a claim of double jeopardy based on purported acquittals, the only verdict which can be received and regarded as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered a record in the presence and under the sanction of the court. Citing a juvenile and Lawrence. C, Massachusetts Rule of Criminal Procedure 27A, verdict must be returned by the jury to the judge in open court. It is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. And this is a case called a juvenile, which Mark Betterow and I have discussed at length. And they cite it for the proposition that signed verdict slips showing not guilty entries found in deliberation room after mistrial declared due to deadlock, not acquittals. There's a lot of reasons why this case is very different. Who found them? When were they filled out? A lot of questions. It wasn't the jurors that came forward. It was I think a janitor that found some slips in a garbage pail. Very different. The jurors here did not return, announce, and affirm any verdict. Their only open and public unanimous acts were their statements to the judge that they were unable to reach a unanimous verdict or to attain consensus, remained at an impasse, and were starkly divided on whether the evidence was sufficient to establish the elements of the charges. The trial judge correctly ruled that the defendant was not acquitted of any charge. Oh, that was in a different case called Brown. The requirement of an open and public verdict announced and affirmed in court is not a mere formalism. Public affirmation in open court provides safeguards against mistakes. It also protects each juror's right to reevaluate their position and to change their mind on any issues or their vote on any charge during deliberations. Here is footnote 9, where they just cite some other cases. I'm not going to read that part. I'll leave it here in case you want to come back and read it for yourself later. None of the cases relied on by the defendant holds otherwise. Those cases addressed criminal proceedings terminated by judicial action, not a jury's determination on the evidence and the law. Citing some more cases here in footnote 10, which you can go and just Google for your reading pleasure if you choose to do so. The defendant's argument proceeds from a selective quotation of those cases, removing the references to judicial action. The omission is significant. With judicial action, double jeopardy principles distinguish between a ruling on the merits and a ruling on procedural grounds. The substance of the ruling, regardless of its form or how it's styled, makes a difference. There is no such distinction with a jury determination, and judicial action does not require the safeguards that are served by the verdict requirement. Judicial action and jury determinations occur in different contexts. The rule of the former does not logically or necessarily extend to the latter. Even granting the defendant her flawed premise, there were no acquittals here for the same reasons as in Bluford and a juvenile. In Bluford, the foreperson disclosed to the judge that the jury had voted unanimously against guilt on 2 of the offenses, was deadlocked on a 3rd, and had not voted on a 4th. See Bluford. The jury continued to deliberate, later reported to the judge that it had not reached a verdict, and the judge declared a mistrial. The defendant there similarly argued acquittal is a matter of substance, not form, and that he had been actually acquitted of 2 of the offenses based on the foreperson's report of the jury's unanimous votes. The U.S. Supreme Court expressed no approval of his premise of substance, not form, and instead rejected the argument on its own terms. The foreperson's report was not a final resolution of anything, the court held, because the jurors continued to deliberate after that report and were therefore free to revisit their prior votes and to change their mind. Okay, but that's distinguishable from this case, the Karen Reed case, because all of these jurors that came forward, more than 1/3 of the jury came forward and said that they were final on those. That's how it ended. The court further noted that it would be unjustified to assume the reported votes did not later change, given the possibility that even a single juror could have rethought their positions on those offenses. Likewise, in a juvenile, this court held that the signed verdict slips showing not guilty entries, which were found in the deliberation room after the declaration of a mistrial due to a deadlock, did not constitute acquittals. It was not enough to show that the jury may have agreed on some issues at some time. Otherwise, uncertainties would be invited. Yeah, but here we have the actual jurors, not just a slip that was found in a garbage pail. As the defendant points out, there was no indication as to when the entries were made or in what circumstance, much less that they reflected a final unanimous conclusion of all jurors. The same is true of the purported juror statements here. A closer reading of them reveals that they do not identify at what point during the 5 days of deliberations the jury allegedly reached unanimous agreements on 2 of the charges. Okay, I'm going to say it again for those louder in the back, for those who didn't hear me the first 700 times. No juror has come forward to say that's not true. That is significant. And again, what's the harm of asking? What is more important here? The constitutional rights of a defendant or bringing the jurors in for 20 minutes to answer one question? I think I'm just going crazy. As such, they do not foreclose the possibility that the supposed unanimity perceived by some jurors was based on a preliminary discussion or straw poll conducted early on in or at the start of the deliberations, the very scenario cited by the Supreme Court as a cautionary example. Oh, and also remember that Judge Canoni was very, very emphatic in her suggestion to the jurors that they do not do that they do not go back and take a straw man poll, or what they're calling straw poll here, where they just go around the table and say, okay, who thinks guilty? Everybody raise your hand. Or who thinks not guilty? Everybody raise your hand. She told them not to do that, right? Remember? Quack Job says, can we get Will on here to read the third letter? You guys are hilarious together. Yeah, he does have to come over to my place this time, so we'll see. Thank you. Thank you very much. I'm waiting to hear from Defense Diaries to see if I'm supposed to go on there tonight to do a primer on Delphi, but I haven't heard back yet, so I'm going to assume that we're not doing that tonight. It's already 3 p.m. my time. They're an hour behind me, though. They're in like Chicago-ish area. All right. Do you guys remember when she told them not to do that? Sturlock says, I've been blind since birth, and even I can see that this is a cover-up. Anyone who can't see it is blinder than I am. That could be the comment of the day, Sturlock. That's amazing. Thank you. Thanks for chiming in. Kathleen, I can't believe they responded using those same cases that 2 months back it was so obvious that they don't apply. They're still doing it. Still doing it. Who's traveling today? I don't know. I was talking to Allie yesterday. I think Allie's home, and I think Bob Mata is in Delphi, but I think Allie's home, yeah? I don't know. Look, Cupcake, you got all the deets on all the sitch. All sitch. Can Will handle the lack of sentence and answers? I don't know. Travis, we're doing it. And I will post it as a community post. All right. Here we go. Now let's get through this. How many more pages do we have? It's like the never ending. It's like the brief that never ends. Just goes on and on, my friends. The trial judge properly rejected the defendant's attempt to bolster these statements with a post-trial inquiry of the jurors, as it is well settled that inquiring into the jury's deliberations, including a juror's individual or the jury's collective decision-making or thought processes, is impermissible. See all of these other cases. The defendant argues that an alleged unanimous but unannounced agreement among the jurors should be considered the type of overt factor that is an appropriate subject of inquiry. Well, yeah, I would argue that too. But in Fiddler itself, this court explained that a jury's decision-making process, any individual juror's thought processes or mental impressions, the reasons for the jury's decisions, or anything else that intrudes on the jury's deliberations do not constitute overt factors. I could repeat myself again, but I won't. And there's another footnote there that is not that interesting. The defendant further argues that inquiry should be permitted here because double jeopardy is a fundamental constitutional right. It kind of is. Kind of is. The appeals court rejected a similar argument in Commonwealth v. Di Benedetto, where it noted that if logic were to control, an inquiry could be made whenever bedrock constitutional rights are implicated. The exceptions would swallow the rule. That's Di Benedetto declining to permit inquiry into whether a verdict announced in court was unanimous. See also a juvenile. Attempting to establish any alleged unanimity reached by the jurors here in the course of their deliberations would necessarily entail proscribed inquiry into deliberations. Although the judge accepted the purported juror statements, which contained 2, 3, or even 4 levels of hearsay, as true and accurate for the purposes of deciding the motion, she explicitly disagreed with the defendant's characterization of those statements as being strong and uncontradicted. So there it is again. The judge did accept the statements as true and accurate, and yet she still decided the way she decided. For one thing, the statements directly contradicted the jurors' notes during their deliberations, including their final note expressing their stark divide as to the elements of the charges. Okay, that note was written by one person. One person wrote that note. You did not get 12 notes from 12 jurors. You got one note from the foreperson who wrote that note. So now trying to put that note onto all of the jurors is kind of a little bit disingenuous, but whatever. I'm not going to beat a dead horse here because this is a pretty dead horse. If you haven't seen or read the ACLU brief, go back and watch my show from yesterday on that because it makes so many excellent points that this is just like they're just repeating and repeating and repeating and repeating everything we've heard 100 times. The defendant says the juror's reference to charges can be readily understood to mean the OUI manslaughter charge and its lesser included offenses. That is not the more natural and straightforward reading, nor is it consistent with the defendant's position at trial. For the defense to now claim that the notes were susceptible to different interpretations such that the court should have inquired further rings hollow, particularly where Attorney Yannetti had twice argued that the jury had engaged in due and thorough deliberations and could not agree. But more importantly, it does not matter how the defendant now in hindsight interprets it. It matters what the jurors meant at the time and why they said it. That cannot be determined without inquiring into their thinking and deliberations. No, you don't need to ask them what they talked about. You don't need to ask them what they were thinking. You don't need to ask them what was discussed. You need to ask them the very simple question. Did you agree to an acquittal on count 1? Yes or no. Did you agree to an acquittal on count 3? Yes or no. That's it. It's a yes or no question. God, this is like, just let me see how much more we have here. Not too much more. Okay, we can get through it. We can get through this, you guys. We can do it. We can do it. We can do it. As another example, according to Juror C, the jury was unanimous only as to second-degree murder, and the remaining charges were not. No. Back to 1. As another example, according to Juror C, the jury was unanimous only as to second-degree murder, and the remaining charges were what they were hung on. Footnote 12. There are additional contradictions. Juror B said that following Tui Rodriguez, the deliberations turned into a bully match. Juror C, however, said that the jurors all got along and never heated. They agreed to disagree and respected each other. Juror B also said that the jury's vote on the OUI manslaughter charge was split in half. Juror C said that the note started polling at 6-6, but ended deadlocked at 4 no, 8 yes. And the purported juror who left a voicemail for the prosecutor said the final vote was 9-3 guilty. Apparently, even if the 5 purported jurors, to say nothing of the 7 other jurors, were not of one mind. These and other discrepancies would need to be reconciled to establish with any confidence whether, in fact, or to what extent any unanimity may have been reached, and that would require an impermissible inquiry into the jurors' deliberative process. Additional considerations militate against the requested inquiry. Jurors questioned at this point, more than 3 months after they were discharged, may feel pressured to provide responses that they believe will minimize their risk of being harmed or harassed. Oh, I was waiting for this. I was waiting for this argument. I was waiting for it. Here's the thing. We are now in October. This motion was made in July, wasn't it? Was it July? The jurors started coming forward the day after the verdict, July 2nd. Who's responsible for this delay? As described in the judge's order impounding the list of the jurors' names and in Juror Doe's affidavit, people associated with this case have been charged criminally with witness intimidation. Oh, yes, they have. Individuals have also expressed outrage at the jurors and sought to identify them and release their personal information for the purposes of harassing and shaming them. Juror Doe said they fear for their personal safety and that of their family, and they worry that they will be subject to harassment or even physical harm because of what they did or did not do on the jury and the outcome of the jury's deliberations. Several of the purported jurors also wish to remain anonymous. And that is footnote 13. Several of the purported jurors also wish to remain anonymous. Okay, well, what are you citing for your supposition there? Number 13, footnote 13. The defendant claims that in the context of this highly publicized case, strains credulity, to suggest that if the purported juror statements did not represent the unanimous view of all 12, the remaining jurors would allow the inaccuracy to go uncorrected. Clearly, there is another reasonable explanation for why other jurors have not drawn further attention to themselves. See also the record on page 331, Juror B stating they believe other jurors have been reluctant to come forward because there's so much public and media attention focused on this case. The concerns are forward-looking as well. The proper evidence of the decision of the jury is the verdict returned by them upon oath and affirmed in open court. It is essential to the freedom and independence of their deliberations that their discussions in the jury room should be kept secret and inviolable. And to admit the testimony of jurors to what took place there would create distrust, embarrassment, and uncertainty. Quoting Fiddler, quoting Woodward from 1871. Well, the ACLU went back to the 1600s. I think their case is stronger than yours, but if jurors' deliberations are allowed to become the subject of post-trial inquiry because of purported statements like those here, future jurors may be hesitant to express their views fully and honestly during deliberations. It also may be more difficult to find jurors willing to serve, both in the retrial here and in other cases when jurors know their service may not end when the trial ends, but could instead subject them to further inconvenience, embarrassment, or harassment well into the future. Well, we saw that in the Maya Kowalski case. For those of you who covered that case with me, I didn't live stream the entire trial, but we did cover it at length. In the Maya Kowalski trial, that was a civil trial out of the state of Florida. It was a case by a young girl and her family against a hospital. And a lot of crazy shenanigans went on during the course of that trial. But in the end, the jury came back with a verdict against the defendant hospital in excess of something like $260 million. The defense attorneys went like straight to Reddit and started pulling Reddit threads for their legal arguments. And they eventually wound up doxing like juror number one and juror number one's wife. They wanted juror number one's cell phone records, his wife's cell phone records, because apparently juror number one's wife was called Hippo Lover in some YouTube chats, and she was sending super chats, and it was like a whole big thing. And they brought juror number one back into court in open court. And the judge asked him questions and then eventually found there was no juror misconduct on the part of juror number one. But we see this more and more in cases. We saw it in Murdoch too, with regard to potential jury tampering by the clerk of the court, Becky Hill. And that's a criminal case, but we're seeing this a lot. And here, I don't think this is a very strong argument when all we're asking to do is to ask them yes or no, did you acquit on charges 1 and 3, yes or no? We're not asking for their cell phone records. We're not asking for spousal communications. And that was a civil case. This is a criminal case where a criminal defendant is looking at potential life in prison based on the rulings of this court and violations of civil rights. Conclusion: for these reasons, the Commonwealth respectfully requests that this case be remanded to the county court for entry of a judgment denying the petition. XOXO, Michael Morrissey. And it's signed by Caleb Schillinger, who I imagine is the Harvard-educated attorney who will be arguing this before the SJC on November 6th. We are here for it. I'm here for it. I'm hoping you, too, will be here for it with me. Let's go to the chat. YouTube terms, I think I already thanked you for the memberships. If I did not, thank you, thank you, thank you. Gail Taylor. So many discrepancies throughout this trial. What's the chance of them reminding Karen Reed? From what I see, there's folks asking for this. What do you mean? Remanding? I'm not sure what you're asking. Dismissing the charges? Putting her in jail? I'm not sure, Gail, what you're asking me. Thanks, Dewey. This is my favorite membership. Has been with me for 3 months. Thanks, Dewey. Jamcracker, thanks for the 10. Melanie Haas, if at all uncommon is it for the judge to choose the jury foreman before the alternates asking for a friend? It's different in every state. It's different in every state. In New York, juror number one is always the foreman or forewoman. It is just, it's by seat number. And here she chose the foreman, and then they pulled the alternates out of a bingo container or a lotto type container where they spun it. And so it depends on the jurisdiction. I'm a New York attorney. So in Massachusetts, I don't know. That's a great question. If anybody knows, if we have any Massachusetts attorneys in the chat, please feel free, chime in. Please hit the like, says Cubert. If you're driving or watching on the TV, like us, you can still pop in here to hit the like. Thanks. Thank you, Cubert, for your 5. Misadventures Book Mouse. Thanks for the 5. Now that we found out the foreman declined to clarify matters with some jurors, request to communicate with the court. Yeah, it seems that way, right? Like some of the jurors asked the foreperson if he or she would send a note to the court, and they said, no, I'm not going to do that, or no, we're not allowed to do that. Thank you for the 5. Hey, Nikki, thanks for the 10. FYI, Turtle Boy said 20 minutes ago on Twitter that he's uploading an article on the Federal Letter number 3. It should be up shortly. I'm refreshing his website as we speak. Turtle Boy Daily News, if you know, you know. Thank you. Buzzing for Truth. And that was at 3:06, and that was about not even 20 minutes ago. Do you think in the retrial, the FBI will be allowed, or do you think they'll be allowed to mention the FBI? I don't know. Or do I think that they're going to be able to call the FBI witnesses, the crash daddies? I think they definitely will. Do I think they'll be able to mention FBI specifically? I don't know. It's like go into a roulette wheel and go into like a casino and throw down a whole bunch of money on the roulette table and spin the wheel. That's like, who knows? Anything goes in Norfolk Superior. Baby fish mouth. Thank you. Third better letter out shortly. Yeah, but I don't know if he's publishing the letter, if he's just going to talk about the letter. I don't know. I need to set up a different stream for that because that is part of not the Karen Reed case, but the Aiden Carney case. And I have a different thumbnail for that and everything. If somebody sends me the letter, I'm happy to go over it. But if he wants to break the news and break the story, I'm gonna give him the opportunity. It's his case. So there's that. Charlie Lynn, thanks for the 5. People won't want to be jurors because you won't count their verdicts, making it a waste of their time. Another excellent point. Thank you, Charlie Lynn, for chiming in. Thoughts, questions, concerns, my friends. Put a Q in front of your question if you have an imperative question that we can address right now before we wrap. And that way I will be able to see it better. Better-o. Oh, Maureen Francis, I love how considerate you are. No, Maureen, it's all you. You're so considerate. Smash the like, everyone. Smash the like. What is required for the jury to be sequestered? That's an interesting question because we're seeing that in Delphi, right? The jury in Delphi is going to be sequestered. They're busing a jury in from 2 hours away. They are all required to be in a hotel for the entire case. No electronics, I think. No newspapers. No outside contact with anybody. No, I don't know if they can even have phone calls. I don't know. But that's something that's done. Also, discretion of the judge. I don't know if they do that often anymore. They really don't. Can't remember the last time we saw a sequestered jury. Point one out to me if you can. And who knows what the Massachusetts rules are? I don't know. But Monica, that's a great question. Danielle. Hi, Danielle. Did you send me an email earlier today? I think you did. And you told me that Phelps podcast about this case is coming out at 6 p.m., right? And wanted to know if I was going to cover it. So those of you who don't know, there's a man named M. William Phelps who has a podcast coming out at 6 p.m. on Spotify, I guess. And Turtle Boy had him on his channel, right? I listened to a little bit. I listened to a trailer. That was you, Danielle. I just pulled it up. So thank you for that. I don't know how long it's going to be. I mean, I guess I'll listen to it and see if I turn it off after 5 minutes because I find it annoying. I may not. So will you be listening to it, Danielle? But yeah, maybe we can talk about it if everyone wants a homework assignment and you all want to listen to the podcast and then we can discuss it after. We can do that. Kiki says, Melanie, when I was on a murder case in Suffolk County, Massachusetts, you're on the jury. We chose the 4-person and they did not do background checks on us. Yeah, they call those Corey checks in Massachusetts. I don't know how long ago that was, Kiki, but that's an interesting tidbit there. Hello, Patronus Glow. Hi, how are you? We've missed you. One of the OGs and an amazing moderator. I've missed you all. I might start popping in to help here and there, even though my body has been fighting me. Hopefully soon. I hope you feel better soon, my dear. I hope you feel better soon. We do miss you, Patronus Glow. Everyone say hi to Patronus Glow. Bentley says, why do I feel like I'm taking crazy pills every time we read a Commonwealth motion? You and me both. You and me both. Heather, am I going to go over the Sarah Boone case again? Yeah, of course. Opening arguments did not start yet, right? They were going to maybe start today. Anybody have an update on that? It's hard for me to check socials and the chat and reading and but yeah, we're going back. We're going back to Florida as soon as it starts. I can't do everything. I can't do everything. Just me. I'm one person. Don't be hating. Did they even address any case law or answer the ACLU arguments? No, because these briefs crossed over. They probably had not even been served with the ACLU brief prior to drafting their brief. So no. Good question, but no. Will they be required to perhaps answer some questions by the panel of judges during oral argument regarding points that were brought up by the ACLU? Possibly. I would like to see it. I'm here for it. I'm here for it. I am here for it. All right, you guys, we have been here for 2 hours and 24 minutes. I'm sure. Who did my makeup today? Oh, thanks, Iceman, for noticing. It's just me. I don't have a team. I don't have hair and makeup people. I don't have people for that. But thank you. Thank you so very much for noticing. Nancy Bevs. Complete. Can the public get the transcripts from the sidebars now or not because it was a mistrial? I don't know. I don't know. That's a good question too. If somebody ever pays for the trial transcripts, I mean, they could get them, perhaps. I mean, trial transcripts are public record, and I don't think they're sealed in any way. It's very expensive to get transcripts. So, sometimes creators pay thousands, tens of thousands of dollars, would be in this case, to get transcripts, and they could make them public. I mean, I don't know. That's a great question too. Hey, if I don't know the answer, I'll tell you I don't know the answer. Marcia Smith, what can we expect as an outcome since the ACLU is involved? They get involved in a lot of cases involving constitutional issues. I think that I don't know that we can expect that the outcome will be different, but I think that we can expect that perhaps because they're involved, because Quinn Emanuel is the law firm, which is a huge, very prestigious law firm for the ACLU in Massachusetts, that this case may garner some more attention. More people may talk about it. So, feel free to share this stream out and hopefully more people will talk about it and we'll cover it because we know that worldwide, you guys are interested in this case worldwide. All right. Charlene says, looking forward to your stream for Bettero's third letter, which Turtle Boy said it's the best yet and jaw dropping. Wow. I mean, can it get any crazier than it's already been? Showing the potential conspiracy and collusion by perhaps a Norfolk County District Attorney's Office and or MSP confidential informant and personal cell phones of Special ADA Mello and Trooper Tully and an alleged victim of Aiden Carney, all conspiring together and communicating on their personal cell phones and stuff as such like that. Like it can get worse than that for the Commonwealth and MSP. That's crazy, Charlene. I'm here for it. Can we get objections with grounds? From now on, I wish we could. Also, judge's discretion. Depends. Will this be the same judge? Will it be a different judge? Eden says the Better letter number 3 is the most damning of corruption exposure. Well, I better get off of here and try and get a hold of that. Don't you think? Phoebe Make That Man is maddening. I don't think I'll be listening to that. I'm not interested. Casey Anthony's jury was sequestered for 2 months. Oh, thanks, Kelly, for pointing that out. All right. Thank you, my moderators. Everyone thank the moderators. The moderators are amazing. Moderators are amazing. And Sage, who says, Melanie, more charges were filed for Elijah View's mom and her boyfriend. Justice for this boy. All right. I'll put that on my list of things to do. But you guys in Massachusetts are keeping me pretty damn busy. I'm ready to go and get into Lindsay Clancy because I was reading some stuff in People magazine yesterday about Lindsay Clancy that make it seem kind of similar to the Carly Gregg case in the case of the medication and perhaps postpartum depression. So Lindsay Clancy, but thank you so much, Sage Honey, for pointing that out. And, it's based on give the people what they want. What you guys want to hear is what I will cover, as always. Lindsay Clancy is heartbreaking. Do you think? Yeah, I really do think. A little too ironic. More than 2,000 likes. Good job, everyone. Custom Shadow said, I'm the only one that you will watch Lindsay Clancy with. The New Yorker just did an article on her, Lindsay, and her husband is 100% behind her. He's like, my wife is not the one who did this. I back my wife up 100%. She killed all 3 of their children. It's horrifying. It's horrifying. All right, we are moving on, my friends. Thank you to the moderators for keeping it classy today. You are amazing, amazing in every way. I love you all so very much. To all of you, my channel members, my cupcakes, I love you with all my heart. To Jason Green, who just sent a Cash App, thank you so much. Because for those of you who don't know that YouTube takes 30% of all super chats, which is why I give you scan codes in case you want to contribute. It's always appreciated, never expected. Shauna, thank you also so much for your Cash App. and to everyone else for being here. Viewers, replay viewers, do all the things that YouTube likes. Like, hit the bell, hit the subscribe. Help me beat Vinnie Politan in my personal quest to beat him in subscribers. He doesn't know anything about it. I'm like 10,000 subscribers behind. So I don't know if I'm going to catch up to him, but I would love to. So thank you very much for being here. I love you. And if you have the bell set and notifications enabled on your phone, you will be able to, as such, be advised when I do go live, because like today, oftentimes it's within an hour's notice or two. Just as I say, every day, every time I talk to you, be cool, be kind, be classy. It's not hard. It is really so not hard. Some people out there have a hard time with it. I know that you guys don't. Keep being your amazing selves. You're making the world a better place. Peace. Rock on, my friends. Stay safe out there.